Good day, everyone. My name is Victor Diaz, and I'm the Communications Manager at the ECLT Foundation. I am delighted to be your moderator today. We would like to thank each and every one of you for your presence and your participation in this webinar. Today, we're joined by distinguished panelists from Ardea International, who will share their insights and experience in human rights due diligence at the bottom of the agriculture supply chain. Please note that there will be an interactive Q&A session at the end of the presentation, but you can also share your comments and questions in the chat box. This webinar is being recorded and will be shared on ECLT's social media and our e-learning platform as well later on. So our presenters today are Colleen Theron. She is the founder and CEO of Ardea International. Colleen founded Ardea in 2010 with the vision to harness her niche legal expertise in order to help companies understand how to meet their legal obligations for sustainability and business and human rights and create progressive voluntary best practice standards. We're also joined by Rory Oak. He is a consultant at Ardea International, and he has contributed to a range of projects related to modern slavery, sustainability, developing practical solutions to embed human rights due diligence across supply chains, in line with the law and international standards in many different sectors. So without further ado, I'll give the floor to Colleen. Could you please, Colleen, introduce us to Ardea International and to the international frameworks?
Of course. Thank you so much, Victor, and good morning to all of you. It's morning in the UK, so wherever you are, I hope you're well. And we're delighted to be here today, and thank you for the invitation, Victor and ECLT. As Victor's mentioned, we at Ardea International are specialists in sustainability and business and human rights, with a very particular focus around modern slavery and forced labor. I think what is really sort of pertinent about the way we want to work is that we harness our legal expertise to provide, best practice and legally compliant advice to organizations that we work with. And we really strive to lead business beyond compliance. And if we go to the next slide, Rory, as a business, we work across many different sectors. So not just the agricultural sector, but many other different sectors. And the work that we primarily do is supporting organizations to develop their policies, to build their due diligence frameworks. We underpin that by training, particularly working at executive level, but also at supplier and managerial level. And within that, looking as well at how we engage stakeholders in the different processes. So in relation to this morning's webinar, I was going to take you through some of the developments that we've seen in both, international frameworks and in the law, and speaking a little bit about what we mean by human rights due diligence and effective due diligence around child labor. And then Rory's going to deep dive into the agricultural supply chain aspects. And I think we need to start by understanding that, global supply chains have become incredibly complex over the last 25 years, as we've seen this growth and liberalization in trade. And as a result of that, there has been an enormous governance gap between states' requirements to create effective legislation to manage the impact on human rights and environmental issues, and how businesses operate. We know that many businesses have actually, a bigger impact than in some areas than some governments do. And sort of born out of these issues, we had some voluntary frameworks that have been developed. And the two critical ones that organizations really need to understand, and particularly now as I take you through how the law is developed, get to grips with as to how you manage and develop your human rights due diligence frameworks. And these two frameworks are the UN Guiding Principles on Business and Human Rights, which were endorsed in 2011. They are seen as a game changer. They were seen as not creating legal obligations when they were created. And we'll discuss how that's shifted in the last 5 years. But the UN Guiding Principle framework sets out really clearly for companies the duty to respect human rights. And it creates both operational and foundational principles to help companies to establish that and demonstrate how they are implementing that duty. Now, the OECD guidelines have also been developed over the last 10 years. We're seeing more and more guidelines that are being brought out for specific sectors. So one of them is guidance for responsible agriculture and supply chains. These guidelines are incredibly detailed. I think what I've found in practice is that they are wonderful frameworks. What they do require, though, is for companies to have someone who has the internal expertise to really understand them and pick them and make them practicable. And I think that for many businesses that we've worked with and do work with, that is often a challenge, because the supply chain or the ethical managers are really dealing often with the day-to-day impacts, the day-to-day issues, and carving out time to really understand what is required by these frameworks isn't always possible unless they have an army and a team of people that are there to support them. So I just want to bear that in mind. If you are looking at them, if you're struggling a little bit, you're thinking this is really quite detailed, how do I manage it? I suspect a good way of going about it is just picking out the really critical areas. From Ardea's point of view, we have a number of business briefing notes, particularly on the guiding principles, which you are free to download off our website. And they just provide summary documents to help businesses understand how to apply these frameworks. So when we talk about human rights due diligence, what do we mean? And the UN Guiding Principles provides us with a definition. I think that what is critical is understanding that this is an ongoing risk management process. What we see so often in the businesses we work with or in our training sessions is that a lot of companies are stuck on audit as being possibly the solution of how you understand your negative social compliance impacts or your human rights impacts. But human rights due diligence includes audits, but it doesn't begin and end at audit. It is an ongoing risk management process. And it requires proactively managing your potential and adverse human rights impacts so that you can mitigate and take account for them. And the standard is that of reasonableness and prudence. And for many companies, I think that understanding what is reasonable and prudent is also often a challenge. We often hear the phrase that we're not that big, we're not a Unilever, we're not Diageo, we're not, these enormous companies. But actually, if you have a turnover that is a high turnover, if you have a very reasonable size company of over 500 employees, reasonably you could be expected to have more than just a couple of lines on how your due diligence functions, or no ESG or no sustainability team in place. So I think that that is a particular question that board directors should be thinking about, and companies in how they address this culturally, and what is the reasonable requirement for a company. And a really good example of this is that a few years ago there was a tragedy at Alton Towers, and there was a prosecution around what had happened from a health and safety point of view. And in the judgment of that prosecution, which was against Merlin, the judge said that for a company of its size, it was totally inappropriate what steps they had taken in relation to how they were managing their health and safety. And so I think that test of reasonableness is probably quite a sobering test for companies if we start looking at how the courts might interpret what that might mean. So we go to the next slide. Human rights and environmental due diligence needs to follow a process. The OECD sets out a really clear wheel. It is a wheel because it is ongoing. It is, if you're familiar with ISO, which many companies are, it is also a framework that provides ongoing improvements, plan, do, check, plan, do, act, check. And this is the same kind of thought around it, is that It is a process whereby you start embedding responsible business conduct. Now, I mentioned that when I first spoke about the UNGPs, that it is a voluntary framework. That hasn't changed. What has changed, though, is that as a framework, the UNGPs are now incorporated in many national and international legal frameworks. And what that means practically is that it changes the obligations from a soft law to a hard law requirement. And that means that, businesses will have to understand what is required of them to demonstrate their duty to respect human rights and to implement due diligence systems, to be able to evidence how they are undertaking effective due diligence. Just before we move on to the next slide, which sets out the human rights and environmental legislative landscape, I wanted to mention, as I know ECLT is based in Geneva, and there may be a number of you listening who have Geneva-based or work for Geneva-based corporations. A very particular piece of law that has been enacted in Switzerland is around due diligence and reporting obligations, particularly for conflict zones and for child labor. Now, a few of our clients have been caught out with this legislation. They haven't understood that they are in scope, and they haven't necessarily understood what is required of them. And I think it's just worth flagging that in the first instance, companies that are going to have to comply with that act, and there are requirements around turnover and size, are going to have to particularly think about whether any of the products or services that they offer, whether there's a reasonable suspicion that they have been manufactured providing using child labor. And the way that the law requires you to demonstrate or refute that possible reasonable suspicion is to have effective due diligence obligations in place, which means having a system, and to fulfill certain reporting requirements. Now, that's just one example of a law around child labor issues. But when you look at this framework of change around legislation, you can see that almost in 10 years, there's been an enormous shift from legislation that is reporting legislation to due diligence legislation, and legislation that's incorporating also environmental and human rights aspects. So what that means practically is that, first of all, businesses need to understand, do they have to report? What does that look like? Do they have to do due diligence? What does that look like? So, from our perspective, we recommend undertaking a legislative landscape assessment so that you understand what your obligations are and when you have to fulfill those obligations by. I think the second really key point is that as the laws are addressing, the due diligence laws are addressing environmental and human rights aspects, one should also start thinking about how you ensure that there's no silo thinking around these issues. I know from a practical point of view how businesses deal with environmental and human rights issues are quite different, and they have different systems. The laws drive different systems, they're different requirements. But the fact that the EU laws in particular are requiring organizations to think of both impacts will require organizations to think about how do they streamline these processes, how do they break down the silo thinking, and also, really importantly, what can they learn about what you've already done well in environmental terms that you can pull across in terms of human rights due diligence. So a good example of that is we're working with an organization looking at social compliance, particularly in some of the manufacturing areas in Indonesia and Singapore. And one of the ways that we're tackling that is, alongside work engagement, stakeholder engagement training, is getting them to understand how they might adapt some of their systems, their environmental quality systems, to meet social compliance. And that's, I think that is probably quite an effective way of embedding change, so that you're not putting something separate to what an organization is already got in place. The only thing I would say is that requires cultural change. It really requires the board and the business to buy into the fact that whatever you do around addressing human rights impacts is going to require a certain amount of expertise, and is also going to require a certain amount of resource to be able to be effective. Now, I won't spend a lot of time on the next two slides, other than just to highlight that aside of the due diligence and reporting legislation, we are seeing a massive increase around laws that create import bans of products that are tainted, or again, that there's a suspicion around forced labor or child labor. And this is particularly interesting when you look at when you look at practically what's happened in relation to the USA. If you're talking about tobacco, there was a lot of tobacco from Malawi has been stopped at port in the USA. That means, you know, operationally, you're not selling that tobacco. You can't get it out of the port until you can rebut the presumption that the tobacco hadn't been grown and is in any way tainted by forced labor or child labor. Some of those withhold release orders have been amended, and so that has allowed a flow of tobacco in, but I know that there's one particular company's tobacco is still being held at port. I think it's also relevant to know that the law around import bans is going to change significantly under the EU quite soon. And that regulation is actually more cumbersome than the regulation in the USA. So for anybody that is looking to sell in products and services both into and outside of the European Union, so that's a change. It's not just stopping goods coming in or, you know, services being provided into the EU. It's also going to affect products going out of the EU. So it's worth, again, understanding this, because you're going to have to understand what kind of systems you need to be able to rebut the presumptions under these particularly onerous import regulation bans. So if we move on to the next slide, I think these is just for a reference around some of the protocols and for international legal instruments, particularly around forced and child labor, that should be taken into account when developing your due diligence frameworks. Now, just the sort of last three slides I'm going to talk about before handing over to Rory is that I think, in relation to due diligence, what we are seeing is that, you know, there is an overall requirement to have effective due diligence in place to address negative human rights impacts. Within that, there are certain iterations around child labor, forced labor, modern slavery. Even though they are all issues that are human rights issues and should be put in that framework, there is a different response that may be required in relation to all three aspects. And it is incumbent on companies to understand where their human rights impacts are, and, you know, whether it is there's a higher risk of modern slavery, whether there's a higher risk of child labor, whether there's more forced labor. That can be determined through your risk assessments, through your human rights saliency impacts, risk assessments, and your human rights saliency impact assessments. Possibly also through your human rights risk impact assessments that are done in country. But it is important to know what the distinction is, because it is going to help you create your response to that effectively in your systems and in the operational areas you are working. So I've just pulled out something around child labor due diligence. And particularly because I know ECLT has just created a e-learning on this, and which I think, Victor, does that become readily available one of these days, where we're discussing in more detail what child labor due diligence actually means. I think what is pertinent to know about this is that again, it goes to my point, effective child labor due diligence will possibly require a different response to forced labor or to modern slavery. And actually in 2022, the IOE did some collaboration with Ardea, and we were looking into what does effective child labor due diligence mean. I did a presentation on that in Durban 2 years ago, and we have a paper that we've been working on in a survey, which we would love to know if anyone is interested in perhaps, revisiting the survey with us so we can update it before releasing the paper. But certainly what we've seen is that responses around child labor for companies are often very defensive, quite difficult, very challenging, particularly in terms of different cultures. And when you are looking at your response to this, if we go to the next slide, I think what is critical to remember is that in relation to developing your human rights due diligence frameworks, the first lens that needs to be applied is the lens of risk to people, not the risk to business. And that is a very tricky shift for many organizations, because they are used to working in financial risk. They're used to, even in relation to environment, it's often risk to business because there's a cost that can be allocated very clearly. It can also be demarcated really clearly. I'm an environmental lawyer by background, and it was easier to be able to negotiate your indemnities and your warranties in relation to a sale of a site where there was possibly contaminated land, because you could quantify it. You could walk on the land and you could see where there was perhaps a landfill or methane gas that was coming out. Very different to when you're looking at the risk to people and children, and applying that lens and then understanding what that risk might be in financial terms and reputational terms for a business. And then just my last slide before handing over to Rory is, why should we carry out due diligence? I think the point about the law is the bottom line, but actually what we're seeing across all the businesses and the companies that we are supporting is that actually it's becoming a critical customer requirement. It's becoming a requirement to protect your reputation. In some cases, companies are not able to tender for government projects because they are not able to fulfill the tender requirements. And a softer piece, but a really critical piece that underlines all of due diligence is that stakeholder engagement and improving your relationships with your stakeholders. So I'll stop there. I could probably talk for 3 hours. So happily now move on to Rory. Thank you very much, Victor.
Thank you, Colleen. Thank you so much for that overview of the international human rights and due diligence frameworks, how the environmental landscape and key requirements are essential to implement all this. So just a kind reminder to everybody to share your comments and questions in the chat box, or you can also raise your hand and ask your questions during the Q&A session at the end. So Rory, over to you. Could you please walk us through how can the international due diligence frameworks be implemented in agriculture?
Yeah, thank you, Victor. So now we can move on and make these principles that Colleen has set out in human rights due diligence, international and legal standards, and apply them with a bit of a deep dive into the agricultural supply chain context, and in particular looking at the challenges that apply in a smallholder farmer context as well. So as Colleen mentioned in her summary, and many of you will be familiar with the OECD guidance for agricultural supply chains as well, I'm sure. It is based on the OECD due diligence guidance for responsible business conduct, but it's also reflected in lots of industry-specific frameworks that apply to tobacco. So, for example, the ALP monitoring and enforcement framework, which follows a very similar 6-step process and aims to operationalize the UNGPs and this OECD guidance in the context of the tobacco sector and at farm level. Also, STP reflects the same principles of the due diligence cycle in tobacco. So looking at what those principles actually are, going into the 6 steps here. First, we have the policy commitment, so a company's commitment to embedding responsible business conduct. The policy commitment should always be communicated and have responsibility allocated throughout the business to establish oversight internally and make sure that there's the right buy-in and management support. The second step is identifying, assessing and prioritizing risk. So that's identifying potential human rights impacts and prioritizing them so that the company can focus on the most significant risks and impacts first. We will come back to this and look at it in a bit more detail in a second. Next, the third step is ceasing, preventing, or mitigating, which involves developing a risk management plan to address any identified risks and impacts, and then implementing actions to prevent and mitigate those adverse impacts to ensure that they don't occur again in the future. That might include things like making changes to policies or company practices and changing supply chain management processes as well. And then when it comes to tracking and monitoring, this is really to track the effectiveness of your risk management actions that you've taken in the first 3 steps. So how effective are these? Is there need for improvements to be made? As Colleen mentioned, the cycle is designed to encourage continuous improvement. So the tracking and monitoring aspect is really important for businesses to keep coming back and looking at what they've done so far and what they need to change moving forward. Communication is obviously sharing information on due diligence processes and actions taken and the results and outcomes of those. That's not just public communication, that might also be communication to stakeholders, so your farmers, your employees, making sure that people understand what the company is aiming to do and the outcomes of the actions that it's put in place. And finally, remediation. And this is the other area that I wanted to spend a bit more time looking at later on in the slides, just because I think it's quite a challenging aspect in a agricultural context, and also a really important area. You know, it's making sure those confirmed adverse impacts are addressed and remedied in an effective way that ensures that you don't have recurrence of the same issues. And it's a really important aspect of risk mitigation. I think it's also worth highlighting that the fact that these principles apply beyond the farm level. So the OECD guidance for agriculture covers the upstream and downstream sectors from the supply chain of agricultural inputs like seeds, fertilizers, equipment, things like that, to the production and post-harvest handling, processing, transportation, and even the marketing and distribution in the context of agriculture. And I think this is a really key point to bear in mind as companies develop their due diligence frameworks, because rightly, there is a lot of focus on the farm when it comes to human rights due diligence. That's where the most publicized and obvious risks are. But a lot of companies have also been flagged by labour inspectors in America, the UK and Europe for factory workers and in processing plants and things like that, finding that they have underage workers, and it's been a significant reputational impact to those businesses. So I think that just shows that these principles not only need to apply to the farm, but also the steps in the supply chain that surround the farm and follow on through that production process. So I mentioned that there's particular challenges when it comes to human rights due diligence in agricultural supply chain. I just wanted to take you through a few of those. Firstly, the limited resources and limited incomes in agriculture in many places. This needs to be factored in. I think when companies are setting standards and expectations for stakeholders, it's really important that there's an element of proportionality. So making sure that unreasonable expectations aren't being set for what farmers are expected to implement, and making sure that they have the right level of cooperation, support and capacity building from the company. Another slightly different challenge is the use of informal labour practices. So in many smallholder contexts, the use of informal and often the temporary seasonal labour can make human rights due diligence quite challenging to implement for companies, particularly in terms of having evidence of compliance with the law. For example, we've seen it's particularly challenging to prove that informal workers are paid minimum wages and that their working hours don't exceed the ILO maximum level, or compliance with local law as well, because there's often not the same level of documentary evidence. And in a human rights due diligence, from a human rights due diligence point of view, the companies then need to think of a way to compensate for that lack of visibility through their due diligence processes. The supply chains are often also very complex, which can mean that resources are stretched and risks are quite difficult to identify. And this is why the prioritization of risks and impacts is so important. And that's another aspect that I'll return to in a minute to look at in a bit more detail, because it's a really important one. And then when it comes to the regulatory frameworks, Colleen spoke about the international and national legislation that's being developed in Europe and America, but also the local law is obviously a key thing to consider. And in some areas, there may be a lack of legislation in place at all, or, as is more often the case, a lack of enforcement of those laws. So there's no impetus to meet the human rights standards set by the ILO, because people, you know, aren't considering the fact that they might have enforcement action taken against them. And then stakeholder communication, something that many companies do struggle with, partly due to the kind of practical challenge of reaching such a large number of stakeholders across a farmer base. But it's critical for human rights due diligence, and it's a crucial cross-cutting aspect across all areas of due diligence processes. And then looking at access to remedies, which I'll also come back to, it's just not as straightforward in a smallholder farmer context, I think, because the environment and the practicalities around it aren't conducive to stakeholders being able to easily raise issues or concerns. So again, it's an area where companies, in designing their due diligence processes, need to find ways that they can be proactive in identifying concerns and engaging with people to find out where there may be issues that require remediation, because it's obviously different from, say, a factory context where it's easier to have a whistleblowing line or reporting to your manager or something like that. And on a similar vein, the cultural factors in large agricultural supply chains, you know, companies find themselves having to apply due diligence in many different contexts. And I think it's really important to be flexible and understand that there's no one-size-fits-all solution when it comes to human rights due diligence for this reason. And similarly, the fact that stakeholders are often not aware of the company's expectations or how they can achieve them, which is why stakeholder engagement, again, and capacity building are so important for human rights due diligence. So now looking at two specific elements of the due diligence cycle, starting with the identification and assessment of human rights risks and impacts. These are just some key considerations to keep in mind when approaching risk identification. So, as I mentioned, stakeholder consultation is key and linked to understanding the root causes of human rights risks and impacts as well. And, you know, engaging people to understand the root causes is necessary to be able to take proactive steps to address risks down the line once you've identified them. It's also important to make sure that you have documented evidence and reporting of impacts. You know, whether a company is reporting publicly or internally, it's really important to maintain evidence of the work that the company has done to identify risks, and also regularly update it. You know, we spoke about how UNGPs frame human rights due diligence as an ongoing risk assessment and management process. So it's really key that risks are reviewed regularly, there's ongoing assessments that take place, and a company strives to build a systematic approach to assessing human rights risk. And then moving to the final point here, I think this is worth coming back to in a bit more detail, but prioritizing actual and potential risks so that companies are able to push their energy and resources in the right direction to address the key issues as a priority over maybe smaller risks and impacts that they see. Before I go on to that, I just wanted to show how the points on the last slide fit together into a kind of systematic process. So as to how a company can identify risks by first understanding its operating context, then reviewing its business relationships for human rights risks, and then drawing on the expertise of experts as well as insights from affected stakeholders to build a full kind of comprehensive picture of human rights risks, and to do so in a way that's systematic. So you know that you're not missing any key elements, you're not doing piecemeal work to identify risk, everything follows that systematic process. So going back to prioritizing risk, as you can see, the UNGP set out that companies should assess risks, and first seek to prevent and mitigate those that are most severe or where delayed responses would make them irremediable. So this involves assessing these factors along the bottom. First, the scope, how many people could be affected. Then the scale, how serious the impact would be. Then the link to the business. This is whether the company caused or contributed to the impact, or if it's just linked to the impact, for example, through a supplier or another business relationship. And then finally, irremediability, which is whether remediation would restore the victim to the same position as before the impact occurred. So it's a fairly intuitive framework to apply. So obviously, the bigger the scope, the more serious the impact, and the closer linked the impact is to the business, the higher on your list of priorities it should be to address. And then the same goes for the irremediability factor, which is if you have something that is so serious that it would be very difficult for the company to put right, that makes it a real priority issue to address as fast as possible, because a delayed response might risk making it worse. And then, if there are things where actually it's less people affected, a less serious impact, it's easy to remedy, those things are obviously still important for a business, but they just may need to take a step-by-step approach with what they address first from a human rights due diligence point of view, to address the most severe things first. And then, as I said, to look at the remedy aspect in a bit more detail as well, because I think this can be particularly challenging. Some key things to consider in the context of human rights remediation. So effective grievance mechanisms, which I will come back to on the next slide, because there's a lot to talk about in terms of what makes a grievance mechanism effective and how can companies review their grievance mechanisms to ensure they're as effective as possible. But other elements are, the engagement of communities, which ties into consultation and consent in the remedy process. And I know I keep coming back to consultation, stakeholder engagement, all of those things, but I think it's really important to emphasize those, because through every step of the due diligence cycle, that's a pervasive theme throughout the whole thing, to really make it effective due diligence. And especially, I think, in the context of agriculture, stakeholder engagement is really critical. And then more practically, you've got the effective investigation and development of adequate remediation plans, because these are completely necessary to make sure that your remediation process leads to sufficient outcomes that prevent things reoccurring and also lead to a satisfactory outcome for the affected stakeholder. And then the other principles are actually more that just apply across due diligence as well, that also apply here. So monitoring and reporting of your remediation, capacity building to ensure that you've got the internal understanding of how the remediation system needs to work and what makes a equitable outcome of the remediation system. And of course, the communication and transparency, which is another one of those cross-cutting elements of due diligence. So going to grievance mechanisms specifically as a key aspect of remediation, the UNGP set out these effectiveness criteria that companies can use to evaluate their own grievance mechanisms. And this can be a really useful exercise for companies to consider whether their grievance mechanisms are actually meeting all of these criteria. So when we talk about an effective grievance mechanism, it needs to be legitimate, which means it's trusted by stakeholders. They actually feel safe and comfortable using that grievance mechanism. They don't fear any form of reprisal for using it. It's accessible, so people are obviously aware of the grievance mechanism, how it works, and how they can actually use it themselves. And they need to be predictable and equitable, which means, in terms of the process that's followed to implement remediation where an issue is raised, there's clear procedures, timeframes, people are treated fairly, and they have access to information, which ties into this next point around transparency as well. So, a transparent remediation system, grievance mechanism that's based on engagement means that stakeholders using the system remain informed of the process and consulted throughout to come to an equitable outcome. And then just on that outcomes aspect, you can see here what they mean by rights compatible is that the outcomes conform with internationally recognized rights. So the ILO standards that Colleen showed on the slide earlier, you want to make sure that, you know, the internationally recognized human rights are protected, and the outcomes of the grievance mechanism align with those international standards. So just before I finish off, I've got some high-level steps that companies can follow to accelerate the implementation of human rights due diligence. So establishing a means of documenting human rights due diligence regulations. As we saw, there's a lot of different regulations coming in and a lot of change in the regulatory space. So it's not only important for companies who are based in, say, Switzerland or Germany to have a record of what legislation is coming in. I think it's also really important for, you know, suppliers from other countries who are selling into those jurisdictions where the laws are coming in to understand how those are progressing, to know when their customers are going to start implementing human rights due diligence and will require all of this additional information from their suppliers as well. And then identifying what due diligence processes your company has in place regarding human rights, considering whether those due diligence systems align with international standards such as the UNGPs and OECD guidance, and then assessing what additional data or evidence is required to produce human rights disclosures, which will also apply to customer requests and things like that. And then I think the two final points are around assigning personnel to human rights due diligence and also establishing those lines of communication between people. So governance structures, you might need working groups and things like that to make sure that people are internally able to communicate and embed human rights due diligence effectively. And just before I finish, these are the 10 key features of an effective child labour due diligence framework that we identified in the recent research paper that Ardea produced, as Colleen mentioned. I won't read through them all, so I'm conscious of time, but you can see that they kind of align to the topics that we've discussed today, especially, you know, around setting the tone through public policy commitments, stakeholder engagement, effective grievance mechanisms and remediation processes in particular, and then formal public communications of measures taken. By no means is this a complete tick box list of what companies need to be, but from our experiences, companies making the greatest strides in addressing child labour in their supply chains adopt these practices and can demonstrate these principles. And lastly, we have recently supported ECLT in the development of an e-learning, which enables companies to understand child labour due diligence, global standards, and how to establish a framework to address child labour due diligence in agriculture. So I do encourage everyone to have a look into that e-learning once it's published. And I'll now hand back over to Colleen to cover a few more points before we go on to the Q&A.
Thank you so much, Rory. I think that's very well set out and hopefully really clear to everybody listening. So just really to touch on again about the paper that we've developed and that we're looking to update. And it covers exploring due diligence efforts to eliminate child labour in supply chains, and you know, sets out these 10 features. I think we mentioned earlier on that we had sent out a survey asking for insights around these issues, and so again, I think it would be appreciated if we could have and if Victor could be known, or he can pass it over to us if there's anyone that would be interested in supporting some further insights for us, so that we can develop this paper and make it available probably in 2024. So one other thing I'd just like to mention, and again thank ECLT, because I know that they have previously supported us in disseminating information around this program. We have a online training and support program. It's a 6-week course. It involves a classroom facilitated conversation for once a week. There's a workbook, there's e-learning, there's guidelines, and it covers the 6 sort of critical areas that we've mentioned around understanding what child labour is, And so, again, if you're interested in that, let us know. We'll be running a course in the first quarter of 2024 again. And so I'd just like to thank you all, and thank you, Victor, for asking us to participate. And hopefully there'll be some questions now.
Yeah, thank you, Colleen. Thank you, Rory, for your insightful presentation. It's very interesting to know that Ardea and ECLT are working together and on the same subjects, because this series of webinars has also covered child labor monitoring and remediation, grievance mechanisms, due diligence, and so we're exploring the same content and trying to change this global issue. So I open the floor for questions and answers. If anybody has a question, you can please raise your hand and put it on the Q&A box. Otherwise, I have a couple of questions. So, Colleen, you mentioned that a human rights due diligence is an ongoing assessment process. So how do you think companies can make sure that they stay actively involved in this process and they just don't produce a document that is archived somewhere and say that, yeah, I have what it takes, the requirements, and I'm compliant? It's an active process. So how can they stay actively involved?
Yeah, that's a great question. Thank you, Victor. I think there are a number of things that come to mind about how to respond to that. I think in the first instance, it's also recognizing that addressing the impact of human rights in the business is something that is not limited to, say, just the sustainability team, or particularly in tobacco, the STP team. It is actually something that involves every aspect of the business. So again, for due diligence to be active, we recommend cross-functional teams working together. We recommend that, you know, you start understanding what your critical impacts are, and then, you know, ultimately how you address those impacts should have short, medium, and long-term goals and involve stakeholder engagement. So, you know, certainly just developing a document, putting it on a shelf, like we used to see, you know, in the 90s with health and safety policies. I used to see loads written and then stuck typically on a steel cabinet in a little office somewhere. And only when a crisis hit someone did they actually try and find the policy. So I think you just cannot address human rights due diligence in a static way. It does involve, it involves governance issues, it involves top management, cultural resource input, and proper governance. I think it involves systems where you continually assessing and understanding what mitigation risks you can take, what steps you might have to take around prevention. And for all of these issues, you can't simply put a sticker on it and say it's fixed. You know, it's so complex. It takes years to get these things done. And you know, our experience of working on supply chain due diligence is that it's really a 3-year process at a minimum to start de-risking and embedding the issues that you need to do, and then starting to track and monitor. So I think maybe in response to your question, possibly to make it an active process in the first instance requires a mindset change. And once you have that, then taking hold of how you're going to integrate systems across the business where everyone is held responsible for their part of that system.
Excellent, great. And again, as you mentioned as well, that the legislative landscape is changing as well. So companies need to stay surfing on the wave and yeah, stay up to date. And these kind of webinars are very useful for that as well. So we see that we have a question from Anna. So her question is, what is your experience with supply chains in Africa and Latin America? What are the main challenges in this context in the global South?
Rory, do you want to have a first stab at that?
Yeah, sure. I think the first thing that comes to mind is one of the things I mentioned earlier, and I don't want to go off on too much of a tangent, because I think it's probably like a webinar in and of itself. But I think living incomes is something that we've seen, particularly in the African context where we've been working on the ground in tobacco farming. Because it's so intrinsically linked to human rights due diligence in many ways. It's something that can be, preventative in terms of the root causes of human rights issues. If people are earning living incomes, they're less likely to have their children working on the farms and so on. I think also it's something that's measurable, which is very useful for a company trying to address human rights due diligence. But yeah, I think it's just the way that it's so linked to those the root causes of human rights issues. I think that's one of the main challenges in the global south is living incomes, especially in smallholder farmers.
And I think I would add to that, what we've seen around in Latin America in terms of that kind of experience, again, very different cultures, so very different approaches also, and different challenges to farmers in relation to child labor and other things. So, I think there's a difference between smallholder and commercial farming, different approaches that take place. I think in different parts of Latin America, there are different challenges because of requirements around labor inspections or even, the cultural context. So we've seen, for example, in some areas, it might be the children actually getting to school is a problem. In other areas, it's what happens to the children when school isn't running, what happens to them. A lot of the, we've seen this in coffee and in the tea sector, excuse me, is that sometimes actually what happens to those children is a concern to parents, and having to find preventative measures to put the children, say, into after school clubs to prevent them from being left alone or going into the city and being caught up in drugs and other things. So I think the cultural piece is a big piece, and I think and also, Latin America and Africa also have different landscape issues. So the way that, the countries look and are also creates a different challenge in relation to how you address engagement. If you have hundreds of miles to travel between stakeholders, that is a challenge for businesses. There's challenges around corruption. I think corruption is a huge issue that we don't talk enough about in part of how you draft solutions around these issues, because we know it's not incumbent just on business to address child labor issues, although we are talking about human rights due diligence in the context of business for this particular webinar. But I think, understanding those broader issues politically around corruption and lack of law enforcement is a very critical problem that is making it more difficult sometimes to find the solutions.
Indeed. And that makes me think of the discussions that were held last week at the SDG Summit and at the UNGC Leaders Summit in New York, where they were speaking about gender equality, climate action, water resilience, finance and investment, and living wage, actually, which is the most essential one. And I agree with you, Rory, that is an essential discussion that needs to happen, not only at the company level, but governments, civil society, and that could really tackle the root causes of all these issues that we're facing right now.
And I actually think the point about gender is really interesting, because when you look at global challenges, I think the challenges around gender and culture are by no means solved. And I often think that businesses also don't necessarily look at things around with a gender lens as well. And so not just, that's why I said understanding also what those impacts are, because the responses will be different depending on what the impact is. Is it, is it child labor, forced labor? Is it modern slavery, or is it also gender related issues? So, there's a whole many levels that have to be considered, and the only way that I think companies can start to come to grips with this is really, in the first instance, understanding what their impacts are, mapping those out, and clearly understanding, and then understanding what what leverage they have, or whether they're directly connected to those impacts, or causing or contributing. And once you have that as a picture, then perhaps then being able to start addressing how you manage that impact effectively.
Yeah, exactly. If there are not any other questions or comments, I would really like to thank our presenters today. Thank you, Colleen. Thank you, Rory, for your insightful remarks. So some of the key takeaways in this sense for me are that the concept of due diligence has two main components. So businesses must meet a standard of conduct and discharge its responsibility for human rights and the environment, and businesses must have a process for assessing main responsibility. So human rights due diligence is essential for a company to identify, prevent, mitigate, and account for how it addresses an adverse human rights impact, but most importantly, it is an ongoing evaluation and monitoring process. So thank you everybody for your participation in this webinar. So this recording is going to be available on our website and our e-learning platform. So thank you again for your participation, and have a lovely day.
Thank you very much for having us. Thank you.
Bye bye. Thank you.
Bye bye. Bye.